We have a wonderful panel here today. My name is Sacha Sloan. I am a senior correspondent at the Capital Forum, and I cover tech issues. So starting to my left, we have Catherine Simonsen, who is a partner and co-founder of Simonsen Sussman, a plaintiff-side antitrust litigation firm, and served as an FTC official under the Biden administration. Then we have Rohit Nath, partner and trial lawyer at Sussman Godfrey, who is currently representing writers in litigation against major AI firms. Then we have Elaine Low, a staff writer at The Ankler, who covers labor and business in Hollywood in the streaming age. Jessica Gonzalez, a public policy lawyer and co-CEO of Free Press, a media advocacy group. And then lastly, we have Joe Anderson, a partner at Manatt, Phelps, and Phillips, who advises clients across entertainment and media. So to start, I would like to ask Elaine to talk a little bit about her on-the-ground reporting about how talent and Hollywood guilds are responding to the rise of AI.
It's been really interesting to see over the last 3+ years since the writer's strike and the actor's strike, the way Hollywood's relationship has evolved with AI. I remember being on those picket lines covering the strikes 3 years ago, and AI was this front burner issue, and it was on all the picket signs. But AI then was also kind of more of an abstract big bad. It was something that was sort of theoretical. It was like, we don't want to be replaced, said the writers and the actors. And fast forward to 3 years later, and you're actually seeing AI deployed in many different ways across the industry, in post-production and animation. WME uses ScriptSense, an AI tool. There's major deployment of it. Obviously, Disney's billion-dollar deal with OpenAI is something else that speaks to the evolving way that Hollywood has actually embraced AI. So there's this increasing, almost paradoxical juxtaposition between the way creatives are feeling about it versus how they're actually employing it. And I think there's the sense that this technology is here. Like Bob Iger said as much, during the announcement of the OpenAI deal with Disney, and that if you don't want to get left behind. And if this is something that's going to be as prevalent as email or the internet, it's like you kind of either have to get on board or get left behind, but it's still a very uneasy negotiation that Hollywood is having with itself on how to use it and what those parameters are where you can still protect human creativity.
Yeah, and Joe, I was wondering if you could jump in and talk a bit about how maybe the more famous creators, like top actors and are kind of responding to AI, maybe situated a little differently from lesser-known actors or Hollywood guilds.
Sure, it's interesting, and I like what Elaine said about this difference between the tools these talent use themselves versus how they feel like their livelihoods are going to be destroyed by the existence of AI. It's this dichotomy that I don't think the talent itself is really grappling with it. I don't know that the advisors to the talent, are grappling with well yet either. But I think, again, it's mostly because it is still so new. I was commenting earlier that it's hard to spend any time thinking about what's going to happen 10 years from now because we're so much dealing with what's happening right now in front of our faces. The fire drills caused by it, and a lot of that comes from the large talent, the high caliber talent, and their concerns. We all saw the Brad Pitt, Tom Cruise fight. I'm assuming we all saw the Brad Pitt, Tom Cruise fight scene that was produced by the Chinese AI company a couple weeks ago. That was, oh no, Brad Pitt's gonna lose all of his jobs. And the truth of it is, when we talk to people of the caliber of Brad Pitt, and I'm not actually talking about Brad, but people in his same world, they're not really that worried about it. Right? They understand that they don't want to be replaced, but they don't think they're going to be yet. They think there's still a lot of the marketing, promotional, authenticity levers that they can pull to help market a film or open a film or generate revenue. But what they are excited about is the fact that their careers are going to last longer, right? Either because they're going to be, de-aged, and so you can be a 40-year-old, action hero or a 25-year-old, starlet for much longer than you could before, even with the improvements in plastic surgery and the like. But they're also realizing that the guilds, their agencies, the companies who they're working with to create content, maybe not so much the large studios, they're all in this with them. They sort of want their input. They're coming to them to get them to be stakeholders in different AI projects, and so it's they're more coming to us as their advisors to say, how do we do this, as opposed to how do we avoid this. I think in contrast to music piracy in the early 2000s, when you had large acts like Metallica going against, college dorm downloaders and moms and grandmas who are posting videos on, nascent YouTube channels about their kids with music playing in the background, saying, take this down, stop it now. I think you see a lot more of the talent now saying, no, AI is here. We've got to deal with it. We're not going to put this genie back in the bottle. So figure out in my contracts how this works for me. Which has been a little bit different from the bottom set of the artists who are the folks who make their money by saying one line or being background actors, especially. Those folks are worried, and they probably should be.
Yeah. Before we move on to how companies are responding to this, Elaine, I was hoping to return to you. Just talk a bit about how the Hollywood guilds are responding to this and how this might have factored into contract negotiations.
So during the last round of negotiations, there were some pretty broad parameters that were set up after the strike. Basically, informed consent and compensation was the running theme. And this time around, the Writers Guild, which is about to start its negotiations, SAG-AFTRA right now is currently in negotiations for the Writers Guild is about to start, is looking to be compensated for when studios use their scripts that they've written to train AI models. Now, those studios own the copyrights, but this is a real point of contention for them going into the next negotiation cycle. And again, because the technology is moving so rapidly, I think that makes it more difficult to negotiate in real time. And there was talk of should these talks be extended out to 5-year periods, but even within a 3-year period, so much can change.
Yeah, no, that's really interesting. So what I'd like to talk about next is this kind of interesting difference that I think many people are observing between how some journalists and authors and that sort of media are responding to AI and how Hollywood is responding. We've seen a lot more litigation from journalists and writers as compared to Hollywood, where it seems, at least so far, there's been more deals and maybe some litigation, but not as much direct legal confrontation. So, Jessica, I was hoping to turn to you to talk a little bit about how the kind of media side, like journalists and news organizations, how they're kind of responding to AI, and then we can kind of get into why the entertainment might be a little different.
Yeah, listen, I think it's about what is in their best interest, right? And so Hollywood, and by Hollywood, I'm really talking about the studios, see an opportunity to make more money with putting less in, right? And I'm actually really interested in what you said, Joe, about how differently situated the powerful stars are versus working Hollywood. And I think we ought to be paying a lot of attention to that, especially in our local economy here. Those are good paying jobs for people who don't have the political power to maybe even hire counsel or the money to hire counsel so that they can defend their rights. I think what we're seeing here is a conversation about bargaining power, and it actually ties into the conversation that was just happening or that's been happening all day about the upcoming merger or Paramount's attempt to buy Warner Brothers Discovery. This is going to consolidate different avenues for people and writers and producers to sell their products. And we ought to be concerned about the lessening bargaining power of writers, authors, and folks who do not have a ton of bargaining power to begin with. I think that's part of why you've seen different dispositions from the guilds as opposed to, say, the big studios.
Yeah, and Rohit, I would love to bring you in here to kind of think about your experience representing authors in litigation against AI firms, and maybe why there hasn't been that same move from Hollywood.
Yeah, so I represent a lot of writers, and our firm also represents the New York Times against OpenAI. And I think actually the divide in terms of who has been out there enforcing their rights has been really, you see a lot of writers out there. We're seeing publishers, particularly news publishers out there, filing cases in enforcing their rights against AI companies. There's obviously there's a multi-district litigation against OpenAI, where there are cases from a variety of internet publishers and the New York Times and a group of high-profile authors who I represent. And then there are several other cases where either authors or news publishers have brought cases against other companies. You haven't seen the same reaction from Hollywood. There are a couple of cases filed by Disney and a few studios against Midjourney and some of the smaller players in this market. And I think part of that is exactly what Jessica just alluded to. Part of it is a little bit about how this technology has developed over time. I mean, ChatGPT was released at the end of 2022. And at that point, I think it was very obvious to journalists, news media organizations, authors that this technology was a problem, and they were mass scraping copyrighted works and using them to train their models, and so you saw action over the next year. I think the technology for both music generation models and video generation models has just been slower to develop, and it's only really been over the past 6 to 8 months that we've seen sort of kind of like shocking developments that have gone viral in that space. And I guess the divide that I've been seeing is on the video generation side, you're seeing studios take action when there's like actual infringing outputs, right? If like Midjourney is generating a bunch of Mickey Mouses or Moana characters, like someone is taking action there. Whereas in the large language model context and with respect to text generation models, you're seeing a little bit more of a diversity of theories and writers and news publishers are taking action and taking issue with actually just using their content to either train or ground their outputs, even if they're not taking, generating word for word content. And you've seen some success in those cases. It's not to be self-promotional, but there's the $1.5 billion settlement in the Bart's case, which our firm negotiated. And I think the cases to watch in that area obviously are going to be the OpenAI cases. Will come to a head sometime towards the end of this year, where we'll see summary judgment briefing on the fundamental fair use question, on whether and in what circumstances using copyrighted works to train a large language model can be fair use and when it isn't.
Yeah, no, that's fascinating. Before we
Can I jump in on that point also too?
Please, yeah.
I think there's an interesting dichotomy that I haven't read a lot about and maybe I should write about it. But there's a replacement theory issue here too, right? I don't believe that AI can replace good journalism, but I think that the average person, in terms of what they consume to try and get their news, there very much is a substitution or replacement issue. Where if you think about when you Google something right now and you get the Google AI results, right? Most people take that for face value. I think most people take that for face value, unfortunately, which is sad. But you find out that if I click the link and go one step further, it's not telling me that ET is 10 million years old. It's telling me that ET looks 10 million years old in this article. But now I think ET is 10 million. That's from a podcast I was listening to on the way over. But it's got to be scarier for a journalist or an author who is concerned that people are already not paying me a fair wage. People are already not paying for the value of what I'm giving them, and they're using snippets. They're using TikTok influencers who are delivering news content, I guess. And I'm not trying to pejoratize all TikTok influencers, but there's a lot of them who are just putting things out there for clicks, for ad revenue. Studios and Hollywood, on the other hand, I don't think they're scared yet that they're going to be replaced. I don't think we're thinking that AI is going to create the next Star Wars trilogy, right? It might create a really good Star Wars scene. It might create a really good, interesting Star Wars story or the backbone, but you're not going to get a 2.5 hour, let alone a 9-picture series and all of the content that come off of it out of the current AI that we have now.
And so I think Hollywood can sort of take a step back and say, we're going to wait and see how this plays out. We're going to wait and see how the fair use rulings start to come down. We're going to wait to see where we're going to keep our powder dry a bit longer to see where we can really attack. Also, I think Hollywood is a little bit skittish from the music industry litigations from, almost 20 years ago now, where it's, the big companies going after people for creating, things that are sort of their everyday person stuff, especially with the rise of social media. They don't necessarily want to be the big bad guy either. And so I think there is a real distinction between artists and authors and journalists versus the sort of Hollywood industry. Makes sense why a journalist is going to be like, we need to fight now, and Warner Brothers and Universal and Sony are saying, well, we're still making a ton of money. Let's see what happens.
Yeah. So before we get more into the litigation, Joe, I was hoping, and also Elaine, if you have thoughts here, kind of just to give us a picture of what the deal making between the studios and the major IP holding entertainment companies, between those entities and the AI firms, like what does that deal making look like right now? What are the kind of pace of the deals?
There's two sort of pools that I'm seeing things fall mostly into. One is the deals with the actual AI platforms. The ones that I've been most dealing with are on the music side, the Universal Udio settlement or the Warner's Studio settlement, and how those are starting to be implemented. And we're getting word as we're seeing contract language start to evolve and send to us in deals and permissions and approvals for those our clients who have approval rights into how these are working. And it very much seems like the large companies are trying, or the large IP owners are trying to sort of snip the capabilities of some of these AI platforms when they're doing their deals. We're going to put you into a walled garden. We're going to let you do a little bit, but not a lot. We're going to make sure that there's some original copyright that comes out into the final output so that we have a copyright claim. And we're really going to try and use our heavy thumb to push you down to do it so that you're not competing with us. Right. The other set of the deals, the other pool I'm seeing are more AI tooling companies, right? Whether that's in music, where you're using AI to separate out the various, files of a song, so you can hear the string separate from the drums, separate from the vocals, of an old recording where those stems weren't created separately in the first place, or where you're seeing clearinghouses start to pop up, where people are trying to hold, let me clear this IP for you, and then add my tool into your workflow, whatever platform you're using for your AI, but it'll point that platform to this cleared set of rights as opposed to scraping from wherever or using training that wasn't licensed properly. And the deals for those companies, the IP holders seem very interested in it because those smaller tooling companies, again, I'm not dealing with a one-to-one competitor. I'm dealing with somebody who recognizes that this is technology that's not going away, and they need me and I need them. And as long as, and not as long as, but if we could work something out, then we're not eating each other's lunch anymore. We really are creating something that allows the new technology to help creators who I'm going to be working with or trying to buy projects from anyway. So I think those are the two deals structures we're sort of seeing and how they play out.
And speaking of a deal that's been in the headlines this past week, you look at Netflix's acquisition of Ben Affleck's Interpositive, which is an AI startup that is supposed to help more in post-production. And I think it also really speaks to this very uneasy alliance that creatives have with this growing technology, right? Like, in his press tour, Ben Affleck was like, well, this isn't supposed to replace human creativity, but if you take the dailies, if you take, the footage that we've taken and you train this model on the footage, then it will help you more in post-production with lighting and editing discrepancies, things that would have taken longer to fix in a pre-AI world. But at the same time, there's again this contradiction, right? Of like, we want to be able to use AI to help streamline some things without it replacing people, but inevitably, even on the ground level, and I think to disagree with you a little bit, Joe, about the concern about it replacing workers, is there is very much so, I think, a concern about AI replacing workers at the entry level in Hollywood. Yes. Like the script readers, the people who are doing all of the so-called menial tasks that they're looking to AI to replace. This is where a lot of people, a lot of creatives, editors, people who work in post, in animation, that's where they cut their teeth. That's where they learn the foundations of the craft, of the trade. And if you have AI replacing those simple tasks, what does that do to the ladder in Hollywood? Because I think increasingly, and this is something I've written about recently, is this disappearing ladder, that you don't have an apprenticeship system, you don't really have a way for creatives to find a path, a hierarchical path where they can grow their careers. And if AI is replacing a lot of these entry-level jobs, then what's a creative to do here?
This is what I was also thinking about, of like, who gets entrenched? Who gets entrenched, and what kind of power do they already have? Whether that's because they're already in the industry and powerful, or they have family connections. Knowing what we know about the lack of diversity over time in Hollywood and the lack of like unique storytelling that is finally starting to come into the fold, I'm very concerned about what this, like when we cut off entry-level jobs, what does this mean for the creativity and viewpoint diversity that I think we all, or most of us, would hope for?
Especially when you combine that with a shrinking studio system,
Yeah.
a shrinking ecosystem, given the pending merger right now.
Right.
Well, I had a client, when I was a very young lawyer, I had a client who made very little money, but she worked a lot writing one-line jokes for a video game that needed to be constantly updated. That job doesn't exist now, right? Because you can have AI spit out 1,000 one-liners based off of all of the comedy you can pull together into training, licensed or not, and you can pick 100 of those. Great. So that person no longer has that job, which it wasn't that the job was so much to her, but the experience to keep writing, to keep honing her craft, and then to meet upper-level creatives and learn from them too. You're right. It's this isn't a panel about law firms, but law firms, we're talking about the same thing right now in terms of our junior attorneys. Right, a first-year attorney comes out of law school, they don't know how to do much of anything, and now AI can do it a lot better than they could anyway. So what do you do as a beginning entrant into entry-level position in any career at this point when you've got to step up that game, which means we have to step up training, we have to step up mentorship, we have to build new ladders, and you're doing that in a world where there's actually less capital available for the people who are doing that. There's less time available to do it because AI has made it so we can go faster, so the expectation is to go faster. I fear for the growth of development. Right, and how that's going to change. I've got a 4 and a 2-year-old, and I don't know what their entry-level jobs are going to look like when they're 18, 19, 16, whatever.
I'm also wondering if that joke is going to be funny. Because I got to tell you, I got a 13-year-old, and he's got a saucy mouth about AI. He's like, that's so sus, that's so obvious, that's so basic. Like, is this what we want?
No. Well,
Yeah, so turning to back to the litigation, as a antitrust-focused newsroom, one of the things that I think has interested a lot of us at the Capitol Forum, and particularly the other writers who cover tech, has been this new growing wave of antitrust litigation in response to AI training on copyrighted content. So we've seen some plaintiffs take an approach of talking about the misappropriation or alleged misappropriation of their copyrighted work, but actually using antitrust law to articulate that concern. And so I'd like to turn to Catherine and just kind of talk about what that wave looks like and what those lawsuits look like, and maybe how that might play out over time.
Yeah, it's a really interesting moment in time. I think what everybody is identifying is that we all have this sense that something is wrong, like that we don't want this, we don't want sort of theft of content, we don't want an unfair advantage for a large company, whether that's Google or OpenAI or a merged Paramount Warner Brothers. And so how does antitrust law approach that and address that? We have started to see some lawsuits, including from Rohit's firm, that are kind of a hybrid copyright antitrust, and I would say they are trying to fit what's happening into the traditional antitrust law buckets. So, for example, there's an old form of claim called monopoly leveraging, which says if you have a monopoly in one market, you're going to sort of leverage it to try to monopolize a second market. and some plaintiffs are using that flavor of a claim to try to say, for example, Google is monopolizing its position in search to using that monopoly to try to leverage, and get an advantage in this new kind of generative AI overview, really content creation market. I think one thing that I would like to see more of is thinking outside the box and going back to some of the older laws that have only recently started to be dusted off. And what I would pitch to you all today is that what we really see here is, and I heard another panelist over here talk about it, is bargaining power and entrenchment, right? And long ago, like in the 30s, the form this took is the big grocery stores having so much leverage that they could extract these super low prices from suppliers. They could use them to lower prices to consumers in the short run. They had a really unfair advantage vis-a-vis the smaller mom and pops down the street. And Congress said, we want to make that illegal. So if you have that power, you can't exercise it. You can't go force the tomato supplier to sell to you at a price that's really going to put him out of business. Not only because it's going to put him out of business, right? And the analogy here is the content creators, but because it's also going to make it really hard for the smaller guy down the street who's also buying from all these suppliers to compete against you, because you're going to have a lower price, or you're going to be able to advertise more with the savings you got. Like, that is a really like core and obvious, very, just you can relate to that idea that is unfair, and we shouldn't allow companies to do that. Because what happens is, in the long run, the smaller shops go out of business, and then you have this powerful behemoth in the middle that is sucking content from the suppliers above it, or sucking product from the suppliers above it, not paying them enough for it. But by the way, they also don't have any competitors anymore over here, so they can charge whatever they want downstream, or they can reduce quality, or they can stop providing a variety of content. So this just is so obvious, I think, to anyone. You don't have to be an antitrust lawyer to understand this. But in the last 50 to 70 years, the courts, subject to this very intense kind of misinformation campaign from large corporate interests, have basically rejected this theory of unfair competition. And they've said, look, if you get to, for example, if you get to a monopoly position lawfully, or a monopsony position lawfully, you can charge whatever you want. The antitrust laws don't say, they don't forbid the actual charging of a monopoly price or the payment of a monopoly price. They only outlaw getting to that place. And I would say, no, that's very wrong. Look at the Robinson-Patman Act. Look at the State Unfair Practices Act and unfair competition laws from the 30s. They say we do want to outlaw that kind of conduct. So what I would like to see is thinking much more creatively outside. Let's not try to shoehorn this into tying or monopoly leveraging. Let's explain why this violates the policy and spirit of the antitrust laws, which is reason enough for a court to find that the conduct violates, for example, the California Unfair Competition Law or FTC Act, Section 5. Because if we keep going in this direction, we're just going to have a very few number of powerful middlemen, again, whether that's Paramount Warner Brothers, whether that's Google, and they're controlling everything that's coming in and everything that's going out. And ultimately, I think the biggest damage that causes is that you're reducing the incentive for those upstream suppliers to create the product. That's what the consumers below that middleman want. They want lots of product, high quality, low price, all those things. But if you've got this bottleneck that is not compensating the suppliers above it accordingly at their fair value, then you are just having such suppressed output. And that really is the true evil that antitrust laws from the start were trying to suppress, trying to get at.
That's really interesting, and I think it's really interesting to think about the other antitrust laws that might be applied to this copyright AI situation as well, because so far we've seen some publication, or Penske Media Corporation, which owns a number of entertainment publications, sue Google under antitrust law for misappropriating its work. But that obviously used pretty conventional antitrust laws, Sherman Act, and hasn't really gone for these more recently dusted off antitrust laws. So it's really interesting to hear about how that could be done. Rohit, I'd like to bring you back in to kind of talk about both that antitrust flavor of cases, but also the copyright cases, the ones we were talking a little bit about earlier. And what are the ones to watch, and what are the likely developments that you see coming down the pike?
So I think on the copyright side of things, last year we got basically two competing visions of fair use from two different judges in a couple of these cases. One was Judge Alsop's decision in the Bartz versus Anthropic case, and the second was Judge Chabria's decision in the Meta Platforms case. And my sense is that the way the direction of the law is going to go is going to be some kind of mashup of those two decisions going forward. Judge Alsop said, kind of sort of paralleling what you were saying about, the use of monopsony power but legally getting there. Judge Alsop said that, based on kind of the long history of peer-to-peer file sharing cases, if you got a bunch of stuff for free that you otherwise would have had to pay for, that's a copyright violation. But once you get it, you can make as many reproductions as you want to train a model, as long as it's put to a transformative use. And Judge Chabria said the opposite. He said, look, it doesn't really matter where and how you got it, but the question is there going to be some sort of market substitution or market harm in any other way, in a much broader sense, including some of the stuff that Joe was talking about? Are you going to look at Google summaries instead of clicking on a link? And that's ultimately the fundamental question that will decide the fair use question. As the plaintiff's lawyer, I think both of those are private copyright violations, but we'll see how that plays out. We will get more guidance over the next year, I think. The biggest one is what I already mentioned, the OpenAI MDL. We'll have, summary judgment is scheduled to be briefed over the course of this year. I don't know whether we're going to get a decision this year. My guess, if you were holding a gun to my head, I'd probably say that a decision would probably come down sometime at the end of this year or early next year. That's probably, of everything, the biggest one to watch. The second case to watch is the Thomson Reuters case, which was in the District of Delaware. There was a decision from Third Circuit Judge Bibas, who was sitting by designation in the district court, and wrote what is, I think, a fantastic opinion for rights holders, basically describing how using even pretty low, about the thinnest copyright material that gets about the thinnest copyright protection that you can get, Westlaw head notes, for the lawyers out there, using that to train a competing product is a copyright violation, and he decided that on summary judgment. There is currently an interlocutory appeal pending in the Third Circuit, and so I think that's going to be a really closely watched case. That's on the copyright side. I think the other sort of sleeper interesting area to watch is sort of outside of the copyright space. There are just a ton of creators or people who rely on creative work who don't really have the option to rely on copyright. And what I mean by that is, for any copyright lawyers out there, to be able to bring a copyright case, you need to have registered copyrights. And even if you have registered copyrights, to be able to leverage statutory damages, which is generally the easiest way to prove damages and the way that you can actually bring a case that would be economical, you have to have registered it in time. And so there are a lot of people, a lot of companies, like media companies out there, and creators who don't regularly or don't have a body of registered copyrighted works, and we've seen them turn to other avenues to enforce their rights. And some of that has been the antitrust cases that Catherine was talking about. The other area are people using the Digital Millennium Copyright Act. particularly anti-circumvention provisions. So YouTube creators and the music industry have brought Digital Millennium Copyright Act cases against AI companies saying, look, YouTube doesn't let you, typically, it's not that hard to figure out how to download a video, but you really, there's no download button, and you're generally not supposed to do it. But a large number of these companies went and scraped all of YouTube, and so people have been using that, the anti-circumvention provisions in the Digital Millennium Copyright Act, to say that is, you don't need a registered copyright to bring those claims. So that's one way that creators can kind of create a moat around their content, as if you have some sort of technological protection measure to prevent people from accessing them. And that's sort of an indication of the world we're going in the internet, right, where you have companies scraping all your works. We're just going to see a lot of paywalls coming up. It's going to be a lot harder for people to access content in the future. Then the second sort of species are copyright management information. So you see tons of internet publishers out there. There's a case, like for example, The Intercept has sued OpenAI. Raw Story has sued OpenAI, and that theory is basically that you're scraping all this content, but stripping out the copyright management information and regurgitating something that, you know, when a user asks a question about something The Intercept published, the ChatGPT will generate a response that doesn't include the copyright management information from the Intercept article, but might produce a response that's based on that. And that's because they systematically remove the byline, the copyright symbol, all of the other management information, and you don't need a registered copyright to be able to bring those claims. And so we'll see how those claims are playing out. There's a Second Circuit appeal about kind of like a more mundane issue related to standing that I think will be decided this year, and in the Raw Story case about copyright management information, and there is and then I think a lot of the other issues will probably be decided in the OpenAI MDL related to the DMCA claims. So that's another avenue, and I think it's something that a lot of people haven't been paying a lot of attention to, but it's really important because there are a lot of creators out there, there are a lot of media companies out there that rely on YouTube and essentially ad-supported access to their content on the internet, and not all of them have what I like to call as registration hygiene for their copyrighted works, and so they need to find other avenues to protect their content. And my guess is, obviously I'm on the plaintiff side, so I'm kind of biased, but my guess is they're going to be very successful.
Great, yeah. So as we wrap up the panel, I'm wondering if there's anything we feel like we haven't touched on that we really want to get across.
We'll just say, if we're talking about things to keep an eye on the No Fakes Act that's going through Congress currently right now. I mean, for those of you that don't know what this is, right, the talent, one of the biggest ways they've been able to protect the unauthorized use of their persona, of their likeness, of their image, is right of publicity lawsuits. Only that's a state action. So California's got a great right of publicity jurisprudence. New York does. Tennessee now with the Elvis Act is going to. But it's very scattershot. And so the No Fakes Act is trying to create the first federal right of publicity act, which will allow somebody like a Brad Pitt to go and take down, right, the fight scene between him and Tom Cruise. And unlike the DMCA, they're trying to really work hard on how the put back up mechanics are going to work. Because the problem with the DMCA and copyright infringement takedowns is it's just a game of whack-a-mole, right? You take something down from one place, it goes back up in 10 other places right after, right? It's cutting off the head of a Hydra thing. The No Fakes Act, from what I'm hearing, is they're really trying hard to have there be real requirements of proof to get it back up, right? They first wanted you to have to go in front of a judge to get it back up. That's probably not going to fly. They were something about getting something notarized just to make it extra onerous. Who knows if that'll fly, especially since you can do online notaries these days in most places. But that's the big issue is if we're going to create these non-copyright regimes of protection, how do we actually protect, as opposed to just sort of making it a illusory attempt. Oh yeah, we took that down.
I think
Sort of watch.
one thing that's on my mind, it's been great to be here with antitrust and copyright lawyers. I'm neither. I'm a public policy lawyer. But what I'm hearing is we're figuring out, there's some potential harms, and we're figuring out how do we protect clients, but also people. I'm thinking about how do we protect the public interest. And one thing that we've been tracking is there's been several attempts by the US Congress to shove AI moratoria into federal legislation and must-pass bills. This would preempt states from passing new laws to bridge gaps in existing law to ensure that we're protecting people and consumers. So the fight goes on there, and we're just constantly preparing for that language to be slipped into federal legislation. I think it's something that we all have to be looking out, because in the absence of federal government protecting the interests of consumers and regular people, we need states to have latitude to do so.
I'll be interested in keeping an eye on where this next round of guild negotiations wind up and what those further AI protections are in the next round of SAG, WGA, and DGA contracts. Particularly because while there's always going to be an underlying tension between studios and creatives over compensation, in many ways I imagine that their interests are actually quite aligned in protecting the copyrights, which, in the case of scripts, are all owned by the studios, especially as, in generative AI or in some of these other cases where you wind up with sort of this soup of ingredients, and like, how do you wind up discerning what's what when it comes to compensating a creative for the material that's been used?
The other thing I was going to add, so I was going to add two things. One is on the No Fakes Act, that's a really good flag. And I think, Joe will correct me if I'm wrong about this, I think the deadline for regulations on how kind of like the putback efforts are going to work and basically platform liability is coming out in June of this year. So we should see a lot more information about that. The other thing I think to keep an eye on is there's a lot of litigation related to how these are addictive products and causing like psychosis in teens. And that may have a big impact on what kind of output controls we see on the products. And those cases are tragic to watch, but will be very interesting to see how they play out.
Yeah, and I would just say, to echo the comment or mirror it to some degree about states, I think this is just a call to action to states, right? Like, block the mergers, states. Use your state antitrust unfair competition laws and don't just assume everything falls to the feds and needs to be addressed under federal law. We have a very large nation with a lot of different laws, and let's take a look and try to be creative to solve some of these problems.
Awesome. Well, thank you so much to our wonderful panelists. And yeah, we're going to...